Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about a form of relief in immigration court known as cancellation of removal for lawful permanent residents. So what does this mean? A lot of people over the years have said, well, I know if I've been here for 7 years or 10 years that I can just automatically get my green card, right? And of course, the answer is no. Nothing's automatic under immigration law. And what I'm telling you in regards to cancellation of removal for lawful permanent residents is something that can only be applied for if you are in immigration court proceedings, okay? Otherwise known as removal or deportation proceedings. If you are not in removal or deportation proceedings, then cancellation of removal for lawful permanent residents will not be available to you, and this entire video will not apply to you. It doesn't mean there aren't ways of getting into removal proceedings, but it is a bit more complicated than just thinking you come to the U.S., hide for a certain number of years, and then magically you can apply for the green card. So what is cancellation of removal for lawful permanent residents? Well, first of all, as it says, lawful permanent residents, you have to have your green card. Okay? If you do not have a green card, then this won't apply to you. And what are the ways that people end up in removal proceedings with a green card? Well, the number one way, of course, is crimes. They commit some kind of crime, or they pass themselves off as a U.S. citizen and they get prosecuted. But for the most part, it's crimes. Okay? And there's a subset of crimes that we're talking about, more or less, that will make one eligible or not ineligible for cancellation of removal for lawful permanent residents. Primarily, and most importantly, you cannot be convicted of an aggravated felon. Okay? If you're an aggravated felon and have this on your record, then cancellation of removal for lawful permanent residents is not an option to you. Now, given that, there's lots of arguments that we can make depending on the crime that you have as to why it is not an aggravated felony, why you qualify for cancellation of removal for lawful permanent residents, and why you are statutorily eligible to apply. So given that I just said you don't qualify if you're considered an aggravated felon, it doesn't mean that if somebody tells you, one of your jailhouse brothers or somebody who did some research on the internet tells you that you're an aggravated felon, or even if immigration tells you, that's not the end of the story. Over the last 20 years since IRA came out, we have been fighting up and down in many different courts, state courts, federal courts, district courts, appellate courts, U.S. Supreme Court, and so forth, as to why a particular crime is not an aggravated felony. Okay, now that doesn't mean, obviously, that we win all the time, because that would be impossible. But if I were to compile a list of the wins that immigration lawyers have done over the years across the nation against what was called an aggravated felony under IRA, you would be surprised. It would take quite some time to go through all the cases and all the jurisdictions of wins that immigration lawyers have done. So, given that, don't give up. Now, whether you argue it's not an aggravated felony, or whether you actually are not an aggravated felon, you would have to show, essentially, that, when you're in court, there's this whole application that we have to submit, and what happens is we go through a trial, and then at the end, the judge says yes or no. But we have to show you have the proper number of years of residency, and generally that's 7 years of residency. Generally, you haven't committed a crime within 5 years of getting the green card, and you're not an aggravated felon. Minus that, statutorily you're eligible. So let's say, for example, you have a possession of cocaine offense. that would be difficult in which to adjust status because technically there's no waiver for possession of cocaine. It doesn't mean you might not qualify for something called the Federal First Offenders Act, and it doesn't mean you might not be able to expunge it and get under other sections of law. But when we're talking about crimes that have no waivers available to them, when you can walk into immigration court and do a cancellation of removal for lawful permanent residents, and if it's granted, walk away with essentially it's your get out of jail free card, because you only get this once. So, if you win once, don't go back and start committing crimes. Okay? And so it is a very useful tool that we have in our arsenal in which to help you fight your case, especially if you had a green card. So if you have a green card and you committed a crime and you're in removal proceedings, that's the first thing that's going to come to mind is the cancellation of removal for lawful permanent residents. So if you're in this situation or you know someone in this situation, give me a call. Give my office a call. We'll set up a consultation time. I'll let you know what can be done and so forth. And then we'll go from there. Okay, if you like the video, click like, click subscribe, and more on the coming videos. Thank you.